Mike Godwin, I'm talking to you. I will start naming names. Only works if they're listening, though. All right. Thank you, everybody. We're going to get started with our second panel on government hacking. And I am Ross Schulman. I'm a senior counsel at OTI and working on a lot of the issues you're hearing about today. First of all, I want to thank everyone who tweeted throughout the first panel without any exhortation to do so. And for those of you who are not tweeting but want to, the hashtag is OTIGovHack. Okay, second panel. It's my pleasure to introduce to you our panelists for our panel on government hacking. First up is Paul Ohm, who is a professor of law at Georgetown University Law Center, focusing on privacy, cybercrime, intellectual property, and other issues. Second up is the panelist we liked so much we invited him twice. Andrew Crocker is going to join us again. He flew all the way from San Francisco, so, you know, in case you don't remember, he's staff attorney at EFF. Daniel Kahn Gilmore, also known as DKG, is a senior staff technologist at the ACLU on the Speech, Privacy, and Technology Project. Andrew Grindrod is the Assistant Federal Public Defender for the Eastern District of Virginia and has been defending a few of the playpen cases, so he has some hands-on experience with these issues. Amy Stepanovich is U.S. Public Policy Manager at Access Now, working at the intersection of human rights and technology. Yeah, come on up, guys. Come on up. Don't be shy. You're going to have to get up here eventually. And finally, last but not least, Dustin Volz is a journalist with Reuters writing about national security, cybersecurity, and surveillance. So please join me in welcoming our second panel.
All right, good morning, everyone. It is my pleasure to have seen that earlier panel and to be able to moderate this panel. I want to kind of take the privilege of talking for a couple of minutes just to set some of the table setting, but then I think we really want to turn it over to these experts to talk about the issues. So what I'd like to do, the topic we're transitioning to is away from the VEP process. So how does the United States government and perhaps other governments acquire vulnerabilities? What do they do with them? And what sorts of safeguards might we have in the maintenance of them? And we're going to switch now for this hour to the use of these vulnerabilities, primarily in the form of exploits. And what I really want to do at the outset, and you guys please push back on me, due to the complexity of this topic, right, we could talk about this for hours and hours. Let me try and do a few framing devices to narrow it a little bit, and then again, you can push me off this approach. We're going to talk about law enforcement primarily. We'll talk a little bit maybe about national security, intelligence, cyber warfare, but what we really want to focus on is the use by the FBI and cops of the tools that we're talking about. Primarily, you know, it's a salad of acronyms: NITS for network investigative techniques, remote access searches. I think most of us will just refer to it as government hacking, partly because it's evocative, partly because it's just simpler to say. So we'll talk about that. The second thing I'd like to do is I'd like to kind of really bring in some concrete cases so we can talk about what we know. Now, of course, a lot of this is shrouded in secrecy. The odds are very high that there are uses of these techniques that we don't yet know about, but we will talk about the ones that have come to light. And so what I want to do to set the table, one last thing, is I want to talk about one quick case. By the way, as part of my biography, which is available in the conference materials, I did spend 4 years at the Justice Department in the Computer Crime and Intellectual Property section, CCIPS. I did work on a few of these cases, not on the classified side, or I wouldn't be saying it right now, but I didn't work on any of the cases that I'm about to talk about. What I think is distinctive, and again, push back on me if you disagree with this, is that the government, in the cases we know about, has tended to have search warrants. And so they have tended to have probable cause, and they've tended to go through what we would hope is a neutral and detached magistrate judge. So in some ways, this is very different than some of the email debates that we've had in this town. Number two, they have tended to use direct self-help. They have kind of not gone through the providers in order to both deliver the government hacking malware, to get the person to trigger it or to monitor it on the back end. So in some ways, this is like the stingray debates that we've had around this town. We have had cases involving standalone devices that the government wants to access, see Apple v. FBI, and we've also had cases about people on the network who are discoverable through things like government malware. I would love to hear later on whether that distinction matters. And the last thing I want to kind of put on the table is in a lot of these cases, we've had anonymity, right? And so there's an overlay with lots of things that we've been discussing as a tech policy community. So let me just tell you the brief outlines of this one case. I'm sure it's familiar to a lot of you. In 2007, Timberline High School in Washington State was receiving bomb threats from a person who purported to be a student at the school. The bomb threats were very specific, named names, talked about techniques, told them the time not to be in the math hall, the library hall, or the main office. And then as part of the story, this person, who may or may not have been a student, was using fairly sophisticated techniques to make the discovery of his or her IP address very difficult to obtain. So there was communications routed through foreign countries, for example. And so suffice it to say two things. One, the FBI was pretty much at a dead end, at least using conventional techniques of the kind they've developed. And number two, that this was a real kind of sophisticated actor, not kind of, you know, why don't we just use the latest toys we have because it would be fun. The school was in a state of terror. They had kept canceling classes. And so eventually the FBI tricked the defendant, soon to be convicted defendant, to click a link, and the link basically installed a piece of software that they euphemistically call a CIPAV, a computer and IP address verifier, which phoned home and revealed all sorts of information about the person's computer, most importantly, the IP address used on the public internet, which was then used to learn his identity. Okay, that was the entire story as we understood it before this year. This year we learned one additional tidbit, which may be a distraction for this panel, but I need to say it, which is we learned that the way they tricked him into clicking on the link was they pretended to be a producer of the Associated Press, writing a story about the anonymous hacker, and basically preyed or played on his vanity to get him to click the link. Inspector General of the Justice Department wrote a report last week essentially exonerating the FBI for going for the ruse of journalism under the rules as they existed at the time. Okay, why do I bring up this example? I bring up this example because I teach my students that, you know, hard cases make bad law. You all remember that from law school, those of you who are lawyers. And so the government often will say, look, we're trying to find anonymous bomb threat purveyors and we're trying to find child pornographers. And they make those arguments in context where we know it's literally not true, that they're just looking for garden variety criminals. I want to at least start the panel by saying it might be true, at least given the proven track record in the cases involving government malware, that the government has seemed, as far as we can tell, to show a little bit of restraint and has reached into this particular bag of tricks when they really do have important crimes shrouded in anonymity. Okay? Again, you can disagree with that, but I just want to put that on the table. So let me begin, and I'm just going to ask an initial question to each of you, but respond to my opening if you'd like to as well. So to Dustin, nice to meet you, by the way. Dustin, given your vantage at Reuters, tell us a little bit more about the history of government hacking as we understand it in this country. Again, push back on my highlighting of the Timberline case if you'd like to, and help us understand the kind of broader context here.
Thank you. Well, you summed up a lot of it very nicely there. I mean, to start, you know, government hacking has been, it's not a new phenomenon. It sort of is now becoming more of a policy discussion in DC and elsewhere. But, you know, from what we understand, this has been something that's been going on for at least a couple decades in various forms. But what we do know about it, as you indicated, oftentimes it comes out much later, and it's often just fragments of details through FOIA lawsuits from the EFF or other activists. The Timberland case that you mentioned, we learned more about that last week, about the process and about now internal rules, whether or not the FBI can impersonate a journalist, but it also did deal somewhat with the actual hacking technique. That was 2016. The event actually happened in 2007. So that is almost a decade later. We didn't really find out that they were using that malicious link malware to get in at all until 2014. Again, thanks to our friends at EFF and ACLU. So this is something that's been around in many forms. It has been used to target child pornographers, of course. It has been used to target bomb hoaxers. Even the Sicilian mob was targeted in the late 90s through use of a keylogger. So it takes many different technical forms as to how the government might attempt to hack into a suspect. They go after many different suspects. As you mentioned, unlike a lot of privacy security debates, typically we do see warrants being used here. There have been a couple of really great summaries of sort of the history. Kim Zetter and then also Jenna McLaughlin at The Intercept have both written really good rundowns of sort of what we've learned over the past 15, 20 years about government hacking. So I would encourage you guys to read that if you haven't. I think another interesting point about this is that this is sort of, I'm sure we'll get into this, a sequel of sorts to the encryption debate, or a tangent of that encryption debate that it's really hard to discuss having a policy about having no backdoors, no way in for law enforcement to get in through those means, but then also sort of say, well, government hacking shouldn't be allowed either. And so there is this tension. And certainly a lot of Silicon Valley companies are starting to pay attention a little bit more to government hacking, but encryption is still sort of their priority. And I think a lot of them would rather go down this route than the alternative, of course, of having some sort of backdoor agreement with law enforcement in US or elsewhere. So.
That's great, and I certainly do want to discuss the overlay with the going dark debate with encryption generally, but can we please kind of delay that conversation just for a little bit? So Daniel, let's connect this a little bit to the conversation we had in the first panel. So they spoke generally about vulnerabilities and exploits, but let's talk specifically about the kind of tools we're talking about in these cases. What are the capabilities? What are the risks? And what do you see from your vantage point of the pros and cons of using them in these cases?
Sure. So I'm in addition to working on public policy like this, I'm also a free software developer. So I work on the software, some of the software that's actually been mentioned here, and I work on internet protocols, which are another place where there has been government interference to try to make our communications infrastructure less secure for the purposes of government access. And so we see, we've seen situations where some of the technical capabilities have been used, and then the lawsuits end up being dropped at risk of exposure of these capabilities. So the argument there of like, oh, well, maybe this is a case where we really only are using these for these exceptional cases. I'm not convinced of that. There's a lot that we don't know, and a lot of this goes back to this discussion that happened earlier this morning around how much trust do we have that we're actually seeing what's going on. If these processes are kept secret, we don't actually know what the full range of capabilities are or how often they're used. We have situations of parallel construction where law enforcement is happy to use to claim that they got information via a different channel, and so it's not all entirely exposed as to what we know. As a software developer, as someone who cares about providing concrete functional infrastructure for people to use, I just want to point out that knowing that one of my adversaries is law enforcement puts me in a very odd position where I end up as a software developer, and other software developers will see the same thing. You would like to think that law enforcement is around to protect you and to make things better for you. But in practice, when all of the law enforcement hacking capabilities are shrouded in secrecy, what you end up finding is I actually don't trust law enforcement I can't work with them, right? If there's a vulnerability reported in my software and it gets reported to law enforcement, I might not learn about it. I'm going to actively discourage my users who might find flaws from talking to law enforcement because I want them to talk to me so that I can fix my tools. And so the set of incentives that surround government hacking are really problematic if we want to encourage the people who build the infrastructure that we all rely on to continue to build it in ways that secure us from everyone. And that doesn't just mean securing us against the government. It means securing us against other governments, criminal hackers, or just plain bad implementations. So the incentive process really is an important part of this whole puzzle.
Can we shift briefly as a quick follow-up from kind of systemic risk to cybersecurity and secure software to operational risk of the way that these are sent, deployed, phone home, right? So I'm sure the FBI would say, no, we take all sorts of extra precautions to kind of cabin our use and make sure that this doesn't, escape
Right.
beyond the boundaries.
So one problem that you have is, in legal cases, there's a question of, oh, well, can we see what this exploit is? Oh no, the exploit is top secret. We can't reveal it even to the court, even in camera. We can't reveal what the exploit was. The exploit is the thing that breaks a security promise that the piece of software that the end user is making. The exploit breaks that security promise and permits the delivery of some other payload. In this case, we call it the NIT, the network investigative technique. And so the claim by the government that, oh, these tools are too sensitive to reveal, well, the fact is they've deployed this exploit against multiple people. And any one of those people, depending on how they have their tools set up, could have copied the exploit as it was sent to them across the network and investigated it later. And we do see concrete instances where that's actually happened, where someone has been shipped an exploit that's supposed to be a confidential exploit, but to use it, you have to deploy it. Well, if you deploy it to me, my computer is a tool for making copies. I can make a copy of that exploit. If I have the sophistication, I can figure out what's going on. I can now redeploy it. So just the act of using any of these exploits itself is sort of counter to this idea that these must all be kept secret. So if you have anybody who's claiming that, oh, well, we can't tell you what this thing is, and yet we are actually deploying it in multiple places, well, something doesn't add up there. And I think it's worth interrogating that more closely.
So we have the privilege of being a panel of two Andrews. Andrew Grindrod, this question's for you. I will say it's my understanding that New America did invite the federal government to send a representative. And I guess I'm the closest they could come up with. It's been a long time since I was one of those. But Andrew, you are a federal public defender, and you have litigated these cases, including the Playpen case, which began to kind of get set up in the last panel. Can you tell us a little bit more about that? And maybe as a kind of connection to the last comment, at the end, talk a little bit about this disclosure question and how that's played out in this case.
Sure, and just by way of disclaimer, any views I might express are my own, and my comments should not be taken as relating to any specific case. Okay. But that being said, and Andrew laid this out pretty clearly earlier, but the Playpen investigation was the FBI physically seizes a server that's hosting this website on the Tor network. The website has a lot of child pornography. It's not dedicated solely to child pornography, and it had also a private messaging feature. But the site is essentially within government control at that point, and so the government has two options. They can, one, shut down the site, stop the ongoing distribution of child pornography, or two, they can continue to operate the site and deploy malware or a network investigative technique in an attempt to locate the users of the site. And so the government here chose option 2. And so for about 2 weeks in February and March of 2015, the government, through the FBI, became probably the largest distributor of child pornography in the world. The government deployed malware, or at least, so the government sought a couple of warrants. One was a Title III warrant, which isn't really relevant to our discussion here, I don't think, but that was to monitor, at least shows that the government does think that they need a Title III warrant to monitor the private messaging communications. That's probably right. And the government also then got a hacking warrant to deploy a NIT that would basically send out code to the computers of anyone who navigated past the home page of the website. It would go onto the user's computer and force that user's computer to surreptitiously send back certain information, including the IP address, to an FBI server. And so that was kind of what the FBI did in this case. We've been challenging a couple aspects of this investigation. One is the validity of the hacking warrant itself. And Paul, I'm happy to get into that more later, but I'll kind of leave that piece alone and talk about the second part you mentioned, which is we've been seeking in discovery access to the code that the government used to hack onto our clients' computers. And the government kind of at first resisted giving us any parts of the code. Now they've given us pieces of it, but they're withholding the exploit and the unique identifier generator. So the government, basically the way that they identify the data that's coming back to the FBI is they say that they've attached some unique identifying code to each deployment of the malware. And so when it comes back to them, they match up the code with the deployment, with the return, and that's how they can link these two pieces together. They won't give us information on that process either. And so, Paul, I think what this gets to, in a sense, is the differences between national security uses of hacking and when the government is using these tools to initiate prosecutions, gather evidence that they then plan to use in a criminal prosecution. I think the law is pretty clear that this imposes a different obligation with respect to disclosure, and that's something that we've been kind of battling out in the courts, and obviously was just mentioned in the last comments.
So I don't see Susan Hennessy in the room, which gives me the opportunity to misrepresent what she said. So I'm gonna suspend my orderly, like, one question each, and give any of you the opportunity who want. So this is what I heard her saying in the last panel, and I again, I'm purposely gonna get this wrong. Okay, so I heard her in talking about the playpen cases specifically, and in talking about what takes the form of criminal discovery, which for civil litigators, right, it's nothing like civil discovery. It's far more compressed, and there are lots of different procedural safeguards. I think she was representing the actions of the federal public defenders in these cases as a somewhat cynical attempt to kind of subvert, maybe not national security directly, but broader debates that should be happening in different fora, right? And that instead it wasn't about the rights of your clients, but instead a much more broad side, and I think she was suggesting disingenuous kind of attack on a broader debate. Now, again, probably got it wrong. Let's call her Susan Prime for the purposes of answering this question. I know some of you may want to respond to that, starting with you first, Andrew Gernrod. I don't know.
Right. So.
Or you, Andrew Crocker, right? So.
I'll let you defend yourself first. Yeah.
So I mean, there are real reasons why we need this information, and why any criminal defendant might need this information, right? And this one example of why it's important to have the actual evidence is that because as the government has kind of bled out piecemeal the other parts of the code that now we do have access to, right? Certain characterizations about what it didn't do or is and isn't capable of, or the way it collects information, right? Not that the government through its agencies intentionally misrepresenting anything, right? But defense experts, when they've had the opportunity to actually review the evidence, reach different conclusions.
I mean, can
right?
you give me one really concrete example? Like, we need to know X about the code in order to argue Y, right?
Sure. So, I mean, in these cases, right, the NIT was being deployed like the last week of February and the first week of March of 2015. Residential search warrants, though, were not executed until months later, right? And so the government concedes in public filings that exploits writ large can make fundamental changes to a computer's security, right, that can then be taken advantage of later. So that is, if this exploit, right, can be seen as kind of unlocking the front door of our clients' computers and then locking it quickly behind them, and so that it leaves the computer in a state that's not really fundamentally changed as far as its ongoing security goes, or it can be seen as having kicked in the front door and left it open for several months, right? So if the question is how are we supposed to view the evidence that's found on the computer when it's seized months later, what happened when the FBI either definitely came through the front door and how they came through the front door is relevant, right? And that's something that right now we just don't have the evidence to have our experts opine on. The government will put experts up and tell us what the exploit does and doesn't do, but there's no way to test that if we don't have the underlying evidence.
And I think three of you actually represent organizations that might call themselves civil liberty organizations, right? Do you want to respond to the broader point? Or
Yeah, or go.
I just wanted to follow up that the concern that you're raising is not at all a theoretical concern. We have concrete instances in the past. The German federal government had what was known as the Bundestrojaner, which is a tool that they were using to surveil particular people that they were targeting, and that actively did make those people's computers more insecure. It was an example of a particular tool deployed by a government, for the purposes of what they considered to be lawful, that actually concretely damaged the security of the computers that they were deployed on and potentially put those users at risk of other things. And then that itself raises issues around chain of evidence handling and things like that. So these are not idle speculations. We have concrete examples of these things being relevant in the world.
Yeah, and just to add, I think Andrew did an extremely good job of explaining why concretely he might need this, but that's not his burden to do. The law is actually very clear that you know, the prosecution has a strong obligation to turn over material evidence to the defense. And quoting the Ninth Circuit from just last week, that is a very low threshold. It's not the same as evidence that's authenticated at trial. It's anything that would be material to preparing the defense. And so part of the system that we have set up is when the state seeks to put someone in prison, even for a very serious crime, we have to put them to their burden, and they have to prove it beyond a reasonable doubt. And this is one piece in that chain. And so it's very misleading to say that you don't need this. You don't just because it might not be introduced as evidence at trial. The other thing I would say, and this was made as a point in a lawfare piece that Susan and her colleague Nick Weaver wrote, arguing that people like Andrew and the defense bar wouldn't be capable of holding on to a secret as the exploit in the NIT case. We have procedures for dealing with this. We have sealed evidence all the time. We have the Classified Information Procedures Act for dealing with classified information. Courts are equipped to do this and do this all the time. He's an officer of the court. I think he even has a badge on him right now, probably. We should trust that defense attorneys will do their duty and keep track of secret information, but use it in service of their client. And so this is, in sort of more generally speaking, the system that we've set up for prosecuting crime, and there shouldn't be something special because we have hacking going on. This is sort of the history of surveillance in this country, is that we've said it's too secret to be out in the light of court, and then lo and behold, we go on prosecuting crimes that involve surveillance all the time.
Right, and I think I do think it's important to recognize there are established procedures in place for dealing with highly secretive information, right? So even accepting the notion that just no one can know about this vulnerability, right? The government tries espionage cases all the time. Classified information is part of the evidence, and there are established procedures in place to address those issues. So I think that notion that once we give it over to the defense, it might as well be in the New York Times, I think that's a bit of a red herring.
So in a second, I want to nerd out with Andrew Crocker about Title III and whether maybe that has an answer. But before I get there, so Amy, you recently authored a report for your organization that tried to connect, and again, not just the law enforcement surveillance we're talking about here, but broader categories of use of malware by governments under a human rights umbrella. I do note that on this category of law enforcement, you stopped short of calling for a prohibition or a ban outright on this. And so I want you to kind of address both pieces of that, kind of the broader point of the report, but also where you might see a little bit of error for surveillance.
Sure. So we basically looked not only at what was happening in the United States, because as has been said, we know hacking's been going on in the US since, depending on how you define hacking, the late 90s. But we wanted to look at what was happening in other countries. And for example, Australia has actually had a law on the books that allows them to hack, I think since the same time, since 1999, which is incredibly old law if you think about how long the internet has been around. The UK thinks they can hack, Germany, France, the UAE, countries all over the world are engaging in this activity. And so we wanted to try to take a step back and say, what is the framework that needs to be in place, not only here but abroad, to ensure that certain, to borrow a word from the previous panel, equities are being respected. And for our purposes, the equity that we were most concerned about was human rights. Although we recognize in the report that there are potentially other issues at play here that might necessitate even stronger protections than what we set out. And so that was the first step we took, was this historical look at how things have been happening around the world. And we, after intense discussions with our tech team, because they are much smarter when it comes to how this technology actually works than I am, we basically divided up all of government hacking activities into 3 really broad categories. We said that governments can either hack to cause harm, to control a message, or to conduct surveillance, with the latter category kind of being the largest, or at least the largest that we've seen so far. And looking at the human rights framework, it seemed to us, and we really had to dig in on a lot of tangential activities because there's not a lot of law or policy on the books about hacking specifically. But it seemed to us that what needed to be put in place was this presumptive prohibition on hacking. So the default should be never hack. from a government perspective. And to take a step back, the report dealt with governments hacking like ordinary people's computers. So we specifically took out government to government and wartime hacking because we thought that there were a lot more complicated issues involved there. But a presumptive prohibition on governments hacking into user computer and non-wartime. And then said, maybe it's possible to overcome that presumption. In the first two categories, we couldn't find any example that could overcome the human rights aspects of hacking. But when it came to surveillance, we basically found with very significant safeguards, we actually enumerated 10 and admit, like some people have read them and they're like, this will never happen. Like we admit there are incredibly significant safeguards that governments might be able to overcome the outright ban that we think should be in place on the activity to begin with.
Yeah, so that's a perfect segue, of course, to these safeguards. But before we get there, does anyone on the panel want to argue we should ban, or we should ban in certain types of cases, that the government should, this is just a power our government should not have? Forget about other countries for now, right? On the crazy theory that we have a little bit more control over what our government does, right? Should we ban law enforcement hacking?
I'm willing to say yes. That so, you know, it's not a question of whether the, you know, so I'm not approaching this as a lawyer, right? I'm approaching this as a technologist, as a technologist, who lives in a society with a government, I expect that the government is doing certain things to provide for the public welfare. And I think that government hacking is in contravention to that. So for example, I would also discourage the use of, say you had one way of gaining access to a locked apartment was some sort of concrete destroying bacteria, right? It could eat through the wall of the apartment. If that bacteria couldn't be well controlled, I think you could say with really good justification that it is irresponsible for the government to deploy that and eat through the wall of an apartment, given that it could cause structural failures in all of the other surrounding apartments, and it could be captured and re-released somewhere else, leading to massive infrastructure collapse. Should the government deploy those things? No, they really should not. And I think that government hacking is a similar kind of problematic approach.
Okay. So, anyone else want to come at that a different way?
I would just say that, to echo you earlier, I should have said this earlier, I don't speak for Reuters at all, so just take that, lest I be fired. But, I mean, just the FBI would generally say that a ban would be, they would describe it as unrealistic, right? I mean, they see this as an important part of what they're doing. They see this as Admiral Rogers often says, foundational to their future efforts to pursue criminal suspects in cyberspace. And again, going to the going dark debate, it's very difficult for them to enter a space where they're not allowed to weaken encryption or have any sort of keys to encrypted messaging or content, and then also not be able to engage in any government hacking. FBI Director James Comey and others at the Bureau just don't see that as realistic, and they're not going away. I mean, Comey has 7 more years. These are issues he's going to fight on, and I don't want to describe it as an either-or debate, like take your pick, encryption or government hacking. But I think that is something to be considered going forward. Is that these are in many cases legitimate law enforcement pursuits. It is shrouded in secrecy, but Amy Hess, the FBI Chief of Science and Technology, has started to engage with lawmakers at the House Energy and Commerce Committee earlier this year a little bit about what their government hacking looks like and how they want to work with the private industry in some ways. So it is still very much something we don't know a lot about, but at least in the general terms, the FBI is beginning to engage and acknowledge that this does occur. And they've been forced into that position in many ways, but I just think the FBI would say that that is just not a realistic position for them to be in.
Can I just follow that for 1 second? Because to me, that's how I've long thought about this question. I think it was 8 years ago I was debating Steve Bellovin at an academic conference, and the argument I was putting out there was, I wasn't saying we should, no matter how I say this, it's going to be controversial. I wasn't saying we should intentionally weaken crypto, but what I was predicting was as crypto became stronger and easier to deploy, it would feed the government's need to become hackers. And Bellovin said, I would rather have I'm totally misrepresenting, but Steve Prime said, I would rather have a world with really powerful government hackers and really strong crypto than a world with weak in both cases. And I said, I'm not sure which of those is the lesser evil. I think a super squad of FBI hackers is a pretty terrifying thing for different reasons, right? So if you had to choose one of those two, which would you choose? Or is that a false dichotomy? Is that a false choice? And if so, why? Because to me, it seems like you get one or the other, and to be consistent, maybe activists, maybe everyone should choose the one that they think is the lesser evil, right?
So I think it was said earlier that the government hacking conversation is tangential to the encryption, or has been a distraction from the encryption conversation.
Yeah.
And I actually think it's the opposite. I think the encryption conversation has actually tried to distract from the hacking conversation that we should have been having for 3 decades, and instead we've been arguing over whether or not we should have a secure internet, which is not a question you can argue, I don't think, realistically. Like, no, we should totally have an internet with lots of holes in it. That's ridiculous. We should have been talking about government hacking. Now, should the government be able to hack because we have a strong internet? I don't know if we've reached a good answer to that question. I will argue, though, in the US specifically, I don't know if we've answered if it's constitutional for the government to hack. I think Susan said earlier in a statement that Susan Prime said earlier in a statement that I would disagree with if I was interpreting her correctly, that you can say that SCOTUS approved the constitutionality of government hacking by approving the changes to Rule 41. And I would say that is a total misrepresentation of what SCOTUS did. Not the least because when several of us in the room testified in front of the Rules Committee and brought up the constitutionality, they said, this rule change does not say that hacking is constitutional. Right. So you can't say that a rule change specifically not meant to speak to a subject area all of a sudden then blesses that subject area because SCOTUS approves the change. And so we haven't gotten to the point. The only judge that I feel like has really dug into the constitutionality of government hacking was Judge Smith in Texas, and he said absolutely not.
Right. So the lesson here is if you're on the first panel, don't leave the audience for the second panel. Yeah.
I'd like to challenge the dichotomy that you present, because I don't think that's a fair characterization, that you must have one or the other. The reality of building secure systems is that it's actually very, very difficult to build secure systems that don't leak any information to anyone anywhere. And I don't know that we actually have any examples of those
so you get side channel
ever.
There's
There's all different kinds of ways that.
Don't panic.
I'm saying don't panic. Yes, I mean exactly. Like this is not.
There's phishing, right? I mean, it was brought up in the last one. That's always going to work, right?
Yeah, information systems are complex and difficult. There's always a tendency to want to push information out to third parties because there's some measures of convenience that can be gotten from it. I mean, to say, look, you've got to be okay with government hacking simply because the crypto is going to be too strong that's not a trade-off worth making. We shouldn't be making those trade-offs.
Okay, so this is, talk about the longest wind-up to a question ever. This is a perfect setup. Okay, so let's assume we're going to try and create a system that at least some of the time permits government hacking. We could ban it in certain cases, but let's say in exceptional cases we're going to allow it. So we're now, next year is the 50th anniversary of the Katz decision, which brought us the reasonable expectation of privacy test. But what often gets forgotten is 6 months earlier was the Berger v. New York decision, which focused much more on kind of what ought to be required, maybe under the Constitution, maybe just as a good practice for this newfangled wiretapping. It wasn't that new. And then Congress basically took Berger as a roadmap and created the Omnibus Crime Control and Safe Streets Act of 1968, which gave us Title III, which created all sorts of procedural hurdles the government must clear before they can record your voice conversations. And Andrew, I gather that you've written this blog post that suggests that maybe some of those, maybe all of those should be required. So can you highlight some procedural protections, again, beyond probable cause and beyond neutral and detached judge that you would require before government hacking?
Sure, and I think we all recognize that it's not a one-to-one from old-fashioned wiretapping to installation of malware on a remote mass computer. So there's clearly much more work to be done here. This is a blog post where I'm just gesturing in the direction of it. But there's a lot of things in Title III, and in fact in the Berger decision that Title III is kind of providing a floor for that are sensible when we're talking about this sort of unconstrained hacking. And when a lot of them already come up in your intro and in our discussion. So do we think it's just a serious crime that's being investigated? Do we think it's one of the ones that we really want the FBI to be doing everything it can do to get in to some suspect's computer, or is it something run-of-the-mill like some petty crime that we think, oh well, maybe the equities are outweighed and we shouldn't be using this dangerous concrete-eating bacteria analog. So one of the things that Title III has is a requirement that it can only be used in serious crimes, and there's actually a list of those crimes. I don't see any reason why we couldn't do that for hacking as well. Like, we could just, rather than saying no hacking ever, we can definitely say no hacking for, a petty DDoS attack or something like that. So that's one thing. So we're sort of limiting just outright what types of crimes can be investigated. Then there's other sorts of things that go to these quasi-constitutional requirements that the Supreme Court talked about in Berger. So we have to be very particularized. Even if you have probable cause and you get a warrant, you still have to state with particularity the places and persons to be searched, all that. That's arguably, and I'm sure Andrew would agree with me, one of the ways that the playpen warrant falls down. This is a single warrant, putting aside all of Rule 41, that allows the hacking, the installation of malware on hundreds and hundreds of people's computers. And the warrant, of course, doesn't say, well, those computers are located in Virginia and Missouri and Washington and California and so on. It says any target computer anywhere, and in fact, they ended up being outside the United States. That, from our perspective, fails the particularity requirement of the Fourth Amendment, and certainly would fail the particularity requirements of Title III. So we need something like that. And then there's sorts of analogs that are required by Title III that I think would be like good hygiene for hacking, that would sort of reassure us and go to some of those trust problems that we were talking about. Notice to targets. You actually have to tell someone that you've wiretapped them. You don't have to tell them right away. They might flee or destroy evidence, but eventually you have to tell them. There has to be a report to Congress every year that says how many wiretaps have we had. Why the FBI doesn't have to do that now for hacking, there's no reason. And then I think even if we're not talking about vulnerabilities, zero-day vulnerabilities, I think we should still think about the kinds of questions that DKG is getting at about, what are the collateral effects? Like, is this a tool that has the potential to go out and eat up the walls of all the other buildings around it? And so, while super targeted malware against one computer that we're really sure we know where it is, maybe that's okay. But what about a compelled software update that backdoors something and could go out to lots and lots of users? And then let's consider sort of the harm to the ecosystem of software updates that might cause. That really has a serious collateral effect. And all of this, I think, should be written into the law when we're talking about letting the FBI engage in this very dangerous behavior.
So as a quick follow-up, so in Berger, the court did this. Now, of course, they were talking to Congress probably at the time, and Congress responded. Should a court tiptoe towards some of these requirements, or do we need an act of Congress to create this sort of thing? Or
I think it's both. My sincere belief in EFF has been filing amicus briefs in a lot of these playpen cases, including one of Andrew's, is that courts right now looking at these cases should say that they violate the Fourth Amendment. Contrary to what Susan Prime said, the Supreme Court definitely has not said hacking is legal, and in fact, the most analogous precedent, Berger and some of the other cases on particularity, there's nothing remotely approaching a single warrant that allows the hacking of unknown people in unknown places. That's just anathema to the Fourth Amendment. It's like what we would call a general warrant. So there's nothing stopping a court from stepping in and saying this fails. I think once that happens, or even if it doesn't happen, Congress is well suited to sort of, hash out exactly what we need to have go into this Title III for hacking, as I'm calling it.
So, I guess, and again, if you don't want to follow me here, just roll your eyes at me. I kind of would like us to pretend like we're in CSIPs, and we know that there are child pornographers who are using, hidden services on the Tor network. We know that we're not going to get anything that looks like the IP address that is the bread and butter of our ongoing investigations. I think we can assume, although if you want to push this, that child pornography is like a high priority of the Justice Department, and these are people we want to bring to justice. So given all of that on the table, right, can we make concrete these recommendations? Like, what more should they have done? How should they have changed the investigation? And how would that maybe have lessened some sort of downstream negative impact that occurred in this case?
So this is just one part of that, and I'm not going to be a CSIP prosecutor anytime soon, I don't think. But they were operating this hidden service for 2 weeks, as Andrew was talking about. That's very controversial in itself, but nevertheless, they were doing it. and they had lots of information about the users. They didn't have to get a single warrant to hack every user that logged in. They had the usernames, they knew lots about these users, and they could have gone in a sort of more logical fashion, gone after the big fish first, and then gotten a single warrant to hack the kingpin or whatever, however you want to look at it, and then gone down the list. And I think that's been characterized as just creating paperwork for the Justice Department and the FBI. I don't think that's true. I think that's what the Fourth Amendment requires. I think the Fourth Amendment requires us to say, yes, we're going to go after this person. We're going to use our vast resources to target this person in this place. And there's nothing that would have stopped them from doing that in this case. It wouldn't have interfered with this investigation, and it might well have avoided some of the issues that we're seeing now, where these technical violations of Rule 41, the disclosure of the exploits. We wouldn't be seeing simultaneous litigation in 100 different courts, which know such a high authority as Oren Kerr has said he's never seen.
I think another thing that we actually need to start thinking that courts should have on hand is a technical expert to explain to them what these tools actually mean and what the consequences can be. There is now precedent for that, because in the USA Freedom Act that was passed, we now allow the FISA court to appoint technical experts to explain this. Notably, in a case, I believe it was from 2013, the FBI applied for a warrant and had to reapply 3 or 4 different times because the exploit they kept trying to use did not execute properly. And they kept having to go back. And I could not tell you if the judge in that case understood what that exploit could or couldn't do. I would imagine not, because judges are not necessarily well known throughout the country for understanding technical ramifications of the things that they approve.
We can say with certainty that in these playpen cases, judges have.
So hang on, I want to. So this is you've walked right into something I always say, right?
Excellent.
So I clerked for 2 of the smartest federal judges I've ever met. They were both the kind of first woman in their city to do everything they did in their career. And I believe that if you went before Mariana Felser or Betty Fletcher with a complex case like this, both dearly departed now, they would have understood it far better than any of the other lawyers in the room. So whenever I'm told that judges can't understand technology, maybe they're exceptional. I don't think they're that exceptional. And I kind of push the burden back on the lawyers, right? Isn't it your job, and especially Andrew, maybe you have a response to this, isn't it the public defender, who granted doesn't have the resources they need, to educate the judge and help them get it right?
Yeah, I think that's right on the back end, right? Yeah. So this is all coming up in the suppression
We're talking about
context.
signing the warrant itself.
But yeah, the judge, and this is, warrants are ex parte, right? So I mean, it's the FBI agent who's signing off on it. It's the DOJ lawyer who's signing off on it. But there's no one there to provide really any context, and there's not a hearing by and large. I mean, I don't know what the stats are, but I would guess that there's almost never any kind of hearing or dialogue back and forth about what the technology is implicated. And so I think it's our job in the suppression litigation to kind of teach the judges, but when judges are signing off on the warrants, and that's where the privacy implications really come to the forefront. That's where there's a lack of technology.
I confess that I was talking about the adversarial process, right? So if you're talking about ex parte warrants,
I'm talking about the application
okay.
process.
Okay.
But even in the adversarial process, the defenders in some sense have their hands tied behind their back because they don't have access to all of the information. And so we've seen judges, after a suppression litigation, fundamentally misunderstand how these NITs work, thinking that the search occurred on the government's computer or that the defendant's IP address was disclosed voluntarily to a third party, and therefore the third party doctrine applied and there's no reasonable expectation of privacy. Neither of those things are true. There's really no way of avoiding the conclusion that a search occurred on the defendant's computers in these cases, and yet judges have come to those conclusions in a number of cases. And it is absolutely the job of the adversarial process for defenders to make that case, but it's also, they need to have all the information at their disposal.
On the off chance the judge who wrote that opinion about REP is watching, that is such a badly reasoned opinion. I mean, and it is so flawed on so many levels. But again, I don't need any of you to agree or disagree with me. I'm allowed to say things like that. Okay. So one, to broaden this back out a little bit, and I think you all might be able to say something about this. It's my impression and we had Heather on the last panel. It's my impression companies are not speaking as vocally about the hacking side as they have about the crypto side. And I wonder why that might be. And if I can layer on a second topic that's related, you put the pin in it. I was trying to figure out exactly what that metaphor meant. So I'm going to pull the pin out and tie it into a bow, okay? So you talked about sometimes the suggestion has been that the government has asked companies to subvert the update process, Apple FBI being only one of them, right? So it seems like, to use the same word, there are all sorts of equities at play among the companies. Am I right to think that they haven't been as vocal and as upfront in leading the charge on this, or is that just wrong? Am I getting that wrong? And if it is right, why might that be?
I want to broaden the term companies out to software suppliers. So I mean, there are lots of. I mean, we were just talking about OpenSSL and Heartbleed, and there's lots of software that we all rely on that is not made by companies at all, that is critically important and potentially something that's a target of hacking. So these may or may not be organizations with a lobbying budget. Or a publicity budget. These may be organizations. Some of them do, for sure, and some of them don't. But it's important that we remember that this is not like a universal. We're not just talking about Microsoft, Google, and Apple here, right? The targets of these hacking could come from many other places. And so, in the context of the commercial companies, though, one of the reasons that people are happy to put themselves out on the crypto side is to say, hey, look, here's a thing we want to do for the public. And the government is threatening us to not let us do this nice thing for the public. And on the vulnerabilities side, you have to come out and say, look, we screw things up. We've made some mistakes. Our software's not as good as we've been claiming that it was. That's a harder PR sell. That doesn't mean that they don't actively care about it. Everybody that I know who works for a software vendor, whether it's a proprietary one or a free software one, cares deeply about the security of their software. And if they learn about a vulnerability, they will work hard to get it fixed. And they will work hard to get those patches out there if there's a patch mechanism. But it's a different thing publicly to come out and say, yeah, we really want to get all of our stupid mistakes fixed. So I think that's part of it.
Okay. Anyone else with an opinion on that one?
I just agree with your premise that generally I don't think this is as much a boardroom issue for Silicon Valley companies as the encryption debate has clearly been. I mean, they see that as really an issue of consumer trust that, depending on how it goes, could really affect business models, could affect both here in the US and abroad. You have had some engagement. Someone mentioned Mozilla earlier, and I know that we have some folks from Mozilla earlier on an earlier panel, and today they sort of came out with a wish list of what they want from a VEP process. Google has been active on the Rule 41. Well, Google was active on the Rule 41 debate, initially filing comments saying that if it went forward as proposed a couple years ago, it would be a monumental threat to the Constitution. So there has been some engagement, but generally, and Bruce Sewell testified before Congress back in April about this, it's something that a lot of them are still grappling with. Even though it's been going on for years and years, a lot of the companies are still sort of deciding how much do they want to fight this issue, and is it worth fighting this if it means that the FBI and others are going to be more aggressive on trying to implement a backdoor into their encryption. And I think that, for them, is something that clearly has resonated with the general public, with consumers, and that's their primary concern right now.
I think that some companies have said things that we could always use them to say more, especially as the Stop Mass Hacking Act is pending in Congress right now, and we have about 5 weeks to get that passed before those changes take effect. And I actually think, because I'm the person who people turn to bring the international angle back in, there is bulk hacking authority in Australia, and in the UK there probably will be before the end of the year, because it's written into their investigatory powers bill that's currently in the House of Lords right now. So the idea that governments can go to companies and try to force them to insert flaws into software updates is very real, and it's being written into law. We're not only considering it here, but we're considering it elsewhere. And do you really want the UK government, even if you trust our government here at home, and I'm not saying that I do, but some people do, even if you trust us here, do you trust the UK or do you trust Australia with a vulnerability inserted into your software update on your phone? Are you going to look at that next Android update, whatever candy they're on now, the same way, knowing that a government can tell them to change that?
So one quick follow-up before we turn to the audience to see what questions they might have for us. On this kind of update thing, and the one that you just put on the table, right? So one of the questions that we've been thinking a little bit about is, and I teed this up at the very beginning, is the device versus the network. right? And it's funny because I honestly, from first principles, can't decide which one has more downstream ramifications, is more threatening, is easier to control, helps get over more significant hurdles for law enforcement. Like, should we think of them as two very different activities? So I have your device in my hand and I want to hack it, versus I don't know who you are out on the network and I want to hack you, right? Or are they basically the same thing? Is it a continuum? Like, how would you respond to that question?
I think there's an inherent notice difference between the two of them. If you have my device, I probably know that you have my device. And I am aware and I can fight against that activity if I'm alive, which we knew wasn't the case in the Apple FBI. If you're hacking into the network and getting through that way, you have no notice. And I think that there are a lot more problems in that instance, because how am I going to be aware of this? In a lot of cases, the notice that is supposed to be provided is withheld, sometimes indefinitely, and so you're never made aware. And because hacking tools can act so unpredictably, there might be serious problems that come out of that tool being installed on your device over the network that you'll never understand why these things are happening. And it could infect hundreds or thousands of people who have no connection to the investigation whatsoever if it starts spreading, which means it could be a huge problem.
Anyone else? All right, so let's turn to the audience. If you have a question for us or for Susan Hennessy, please raise your hand, and we'll make sure the microphone gets to you. So if you could wait for the microphone. Thanks.
Hi. So I just want to come back to United States versus Cats versus United States, which we now routinely understand as defining reasonable expectation of privacy as some sort of dividing line about where, what we should allow in terms of process in searches and seizures of communications.
Yeah.
But the actual decision, of course, that's not the majority opinion. That's a concurrence from Justice Harlan, which is now taken to be the great summary of the opinion, which actually doesn't talk about reasonable protection, reasonable expectations of privacy, but in fact talks about the Fourth Amendment as a protection of persons, not of places. And I wonder if that's relevant to the consideration about whether you think harder about network security versus device security. I know we've been talking a lot about that this year. Yeah. And start thinking about in terms of personal protections, because it's more consistent with the international environment that I know Amy and others of us work in, to think in terms of personal protections rather than device protections or territorial protections or network protections. And I just wanted to put that question to the members of the panel.
So just to clarify, so you mean that if we really believe the exhortation that the Fourth Amendment's about persons, not places, right, it might give judges different avenues for robust, improved Fourth Amendment. Yeah, okay. Responses to that?
I mean, I think in a rare instance, you have Cindy Cohen from the EFF and Bob Litt agreeing that the reasonable expectation of privacy might not be enough anymore in our new digital world. Now, that's about as far as they agree, because Litt goes on to say you should only look at use of data and not collection at all. And Cindy, I think, very presciently says we need to start looking at these human rights standards, to be quite clear, of necessity and proportionality to determine if an activity should occur. And that actually does look at this idea of personal protections, I think. I think we do need to start reevaluating how much information is out there. This gets to the third-party doctrine problem that we've been grappling with. It gets to a lot of other problems. The need to start reevaluating for increased protections, because this reasonable expectation of privacy test, the FBI and courts are finding too many loopholes around it.
And I'd add Sonia Sotomayor to that list. I mean, it seems like she's a little fed up with RAP and maybe some of the other justices, but certainly her and Jones. So.
Yeah, I was going to say in Jones, I mean, if you look at the trespass theory, I think there's an analogy there that can be made that, you can say that illicit hacking is so pervasive that we really don't have a reasonable expectation of privacy, but you're not consenting to that. So anyone who is hacking onto your computer and onto your system is, at least according to the government's analogy, right, attaching something onto your computer without anyone's permission or knowledge. That seems an awful lot like a trespass, and so maybe rather than kind of reworking a very difficult and problematic reasonable expectation of privacy standard, turning to trespass and figuring out what that means in the digital context may make more sense.
Kevin?
Hi, yeah, organizer's prerogative, sorry guys. But, you know, we talk about the idea of the need for a new regulation here, like a Title III, a Wiretap Act for hacking. But I want to ask, are we better or worse off if Congress addresses this issue? Because I can see both sides of it. I could see an argument that, you know, several people have been arguing this is an illegitimate tactic or usually an illegitimate tactic. Do we actually want Congress to bless it? There's also the concern that that would be a negotiation that would basically be where DOJ would have a great deal of say, and we could end up with something that has really bad loopholes or like codifies that they can send malware through update channels or a variety of other things. I think the counter argument there is, well, but you know, you don't need Congress's authorization at this point. The government's doing it anyway, so if we don't rein them in through statute, all we have left is the Fourth Amendment, which may save us. But also, yeah, it seems like a risky endeavor, and yet probably a necessary endeavor. I'm curious how you guys are weighing those options.
So you did an admirable job arguing against yourself, so I don't really need to add too much to it. But I think you're right. Like it's happening right now, so there are risks and opportunities to taking it to Congress versus taking it to the courts. My colleague Nate Cardozo, who's a couple of rows back, and I wrote an article saying we shouldn't wait another 15 years to be having this conversation. So kudos to you for having this conversation here. I think that the reason why I think a Title III for hacking is something to talk about is that courts are really good at adjudicating the disputes before them, but we've seen all the ways in which these things don't go to courts. And why it's taken 15 years for us to even have this conversation is that so often they fall off the map, or it's an ex parte warrant application and then doesn't go anywhere. And you know, it may be time for us to have a more public conversation, and Congress is one way of doing that, and getting the transparency forcing function of just engaging and coming to the table tends to bring more transparency, brings FOIA suits, brings intrepid reporting. You know, we tend to learn more when we talk about things in public, and that's where I come down on it.
And I would say the one thing that is weighing, because you kind of argued both sides very well. The one thing that is weighing a little more, I think, in favor of wanting Congress to act is this Rule 41 problem. And you know, I sat here during your Rule 41 event and said, my biggest fear is that in approving or not rejecting Rule 41, that the FBI is now going to start arguing that Congress has blessed government hacking, and that we do have a statute for it, and that we do have authority. And at the time, nobody had argued that yet. And as I said previously, Susan sat up here and said, by approving Rule 41 changes, SCOTUS has said Rule 41 is constitutional. And so I think we're going to start seeing that happening, and I think courts are going to possibly start saying that Congress has spoken by not speaking. And that puts us in a really bad place overall, where we're not even going to get to have the argument.
So, I mean, what I hear in Kevin's question as well, or what I take from it, is the politics seem a little tricky here, right? We don't have something like the Crazy All Writs Act to fire at, right? We don't have a lot of cases where there's been really, really extreme government overreach. No one's talked about, what are they called, freedom hosting, right? So that seems to be something that hasn't been on the table yet. We also have cases against child pornographers and people who make bomb threats, right? So there's always that political risk for the activists as well as for the members of Congress, right? So is that part of the problem? Like, where do the politics cash out? Or maybe to put it in a productive way, what are the entry points for policy? Because to be really frank, or maybe intentionally provocative, I'm not sure it's the infrastructural security piece that's going to win the day in Congress, right? Maybe it is, maybe it is, but I'm not sure they're savvy enough to really even understand that, much less run with it.
So the
right?
infrastructural security is part and parcel of the human rights questions as well, right? I mean, this is a question of, do we believe that people should be able to access information anonymously, right? Do we believe that it's important that someone can, research a disease that they have without their network provider knowing that they have such a disease? Do we believe that people should be able to be confident that the information on their most personal devices, you don't carry a filing cabinet anymore, you don't have one in your home anymore, you just carry everything on your device with you. Do we believe people should be able to be confident in the security of their information? I mean, I think there are real fundamental questions about what we believe and what we value in a society, and the infrastructural piece is how we get there. If we say that infrastructure can be torn down, well, then we're saying that we don't actually value that.
I just want to add that the politics are absolutely very tricky. I think everybody in the room understands that. I mean, Congress is a diverse place with many different lawmakers with many different perspectives, but essentially you have one lawmaker, Senator Ron Wyden, who's really paying attention to this very closely and stepping out and talking about it. He's trying to prevent Rule 41 with his STOP Act. We have some interest in the judiciary committees, of course. Senators Leahy and Lee have sent a letter to Grassley asking for a hearing on Rule 41, but broadly, it is something that a lot of lawmakers, I think, are reticent to address right now because you have these tricky cases out there in the public light, and it's hard, it's complicated, and as the encryption working group in the House shows, a lot of them are still sort of getting up to speed on a lot of these issues. So I think it's, as with any election, it's going to be interesting to see what happens after November for many reasons. But what are the Intel committees going to look like? Are they going to be Democratic, Republican? I think that really will make a difference in these debates going forward. Senator Feingold, if he gets reelected, of course, these are issues that he cares about. That would sort of give Senator Wyden another ally to sort of take these on. So when you consider, do you want Congress involved or not? I mean, it really does matter the composition and where it's going to come from, what committees and going forward. So.
I won't ask the follow-up about a president who urges the hacking of a competitor and how that might change the politics. Any other questions from the audience? Yeah.
Hi. Is that on? Hello. Okay. Tim Retter from the German Marshall Fund. And I appreciate sort of this whole conversation, and with Susan here and others, and the adversarial conversation I'm having in my own head. I always come back to, but also this is enabling nefarious actors to operate with greater speed, greater agility, greater lethality. And none of our law and policy and norms really envisioned this world we've created. So all of this is kind of new. And there was this really good article by Assistant Attorney General John Carlin, I think it was called Deter, Detect, Disrupt, sort of laying out the government's case for why we need some of these authorities. And I think it was Game Over Zeus he talked about, and you had a botnet with 2.5 million computers, and it was spread over many countries. And then they actually tried to sort of help clean it up and then fix it after the fact. So, if you have, whether it's a terrorist group or a criminal group operating also with greater, sophistication, greater, it empowers them in certain ways. How do you then counter that in a way that we're all more or less comfortable with? And he basically said, can we go into innocent computers, clean up the malware, and then try to notify people after the fact? Now, to me, in principle, that sounds good, but technically how you do it, whether the legal authorities exist, and this is affecting the international system too, with mutual legal assistance treaties, and the speed is such that we're not equipped to handle it. So how do you address the negative aspects while also still protecting all of the good things we value? And I don't know if that is really
if you want to take on that in general, but I think the botnet example is a fascinating one, right? And so here well, and at least as I understand it, a lot of that action has come through the independent civil actions of private companies. I mean, bringing the companies back in, most notably Microsoft has devoted a lot of resources to being really clever with the law and doing things that might look like hacking or damage depending on how you frame it. I'm sure they disagree, right? I mean, that's a different context we haven't really put on the table yet. Is that a context where we might like the government hacking a little more? Are there different risks that might make it even riskier? So what do we think about like neutralizing and cleaning up massive botnets as a specific context?
You're describing Microsoft's anti-botnet work, right? Yeah. I mean, some of that is basically software updates that are sent out in furtherance. I mean, so the botnet is a bunch of computers that are operating not on behalf of the owners of the computers. And the owners of those computers, presumably, if they've installed them properly and they're maintaining them, they actually have software update mechanisms to improve the security of the system, which is what they expect. They've signed up with their software vendor and said, please update and fix the problems. So if your goal is squash a botnet, and you know it's running on Microsoft computers, and Microsoft can identify it via a software update channel, That's a software update mechanism. Microsoft can publish what their update is. Because
but what I'm talking about
but I think it's a different discussion,
Sure,
right? If
sure,
you want to
sure.
clean up a botnet, then sure, help the vendors who have vulnerable systems figure out how to get those patches out that defend against the botnet. That is not at all the same as government.
But as I understand it, so part of it is civil forfeiture to seize a domain name, to mimic the control channel, to tell all these botnets to stand down, right? So to me, that seems a little bit more like a judicially sanctioned hack, right? Now, granted, on software that you don't want on your computer and you probably don't even know is there, but it's still changing something about your computer, right? It's under the CFAA, which I'm not here to defend. That's damage, right? You're damaging someone's computer, right? Is that a different context? Do we think different? Like, what if the government did that instead of Microsoft, right?
I mean, the government's trying to do that
Sure.
instead of Microsoft. That's the other part of the Rule 41 changes that we haven't talked about.
Right.
Again, not a technologist. DKG might have more to say to this than I do, but every technologist I've spoken to has said that the government doesn't need to be involved here. Okay. And there actually is no necessary reason for this rule change, which will allow them to not only go to, again, the head of the botnet, but down into every single one of the victims' computers, possibly causing further damage. So you're not necessarily talking about just cleaning up the damage. You're talking about the possibility of further damaging computers of people who are already victims of a crime. And it's a system that we already have in place. We're already dealing with this. I think we're going to continue to evolve the way we deal with botnets. But having the government get involved is not necessarily the answer to that question.
Let me just ask one quick question in closing, and I wanted, Andrew Gernrod, I have a question for you, which is, can you talk a little bit about the role of the public defenders in this case? And what I see as a kind of an exceptional moment where they've come together in this like task force, where they've found technical assistance. How did this come about, and does this say something broader? I'm going way beyond the context of our panel, about the kind of lack of resources that are typically given in our adversarial system to one of the two sides, the side that ostensibly stands for our civil rights, right?
Sure.
Should we be encouraged by what happened, or is this like a real fluke that won't happen again?
I think it's encouraging. I mean, so Colin Feynman is an AFPD out of Washington State and was the lead attorney on the Michaud case that's already been referenced. And you know, obviously during the course of that litigation, he learned that this is not just a case that's going to be have similar cases pop up, but nearly identical cases. It's all based on the same warrant. So Colin has kind of put together a group of federal public defenders who've been coordinating. And I think importantly, like the details here matter about how this is able to come about. So the protective order in his case was specifically written in a way that allowed Colin to share information that he gathered in discovery with other AFPDs. Yeah. And the government has fought similar protective order language in other cases to prevent that coordination. Now, like when Colin had a hearing in his case, right, DOJ lawyers from Maine Justice fly out to argue it. DOJ coordinates, obviously, around the country. Federal public defenders don't have that kind of natural infrastructure in place, but I think this is an example of how it can work and a way that should be emulated in the future going forward. And we can always use more money, so if you're talking to your congressperson.
That's a good place to end. In closing, before I hand it back to the organizers, I do want to say, as an academic, I'm a little jealous and ashamed that so much amazing writing in this has come from the activist community. I commend the reports by Amy and the reporting by Dustin and the blog post by Andrew, and most importantly, New America for taking the lead on this. And the report they've written is fantastic. I urge you all to read it, and I thank you for having the day. Please join me in thanking our panelists.
Thanks, guys. Ross and I just wanted to say thank you all for coming. Thank you again to all of the panelists, the many expert panelists that were willing to come out and spend their morning with us here. And thanks everyone for tuning in on the live stream. This video will be archived on the event site at New America. Thanks a lot, everybody.
This is wrong. This is wrong. This is from Matilda.